Of ethicality of artificial intelligence and machine learning in law with reference to case Puttaswamy versus Union of India case. The next slide. As the theme that is there for this particular conference is related to artificial intelligence and in respect of different knowledge network. Now there is a rise of artificial intelligence and machine learning in legal processes. There is an increase of automation in decision making and surveillance. Now various constitutional concerns, they are related to privacy, fairness and accountability. I mean, there are programs like Topaz and there are other so-called programs in different fields where the where the software related to artificial intelligence is used. The next slide. Now AI and ML, in a nutshell, if I want to show the predictive policing and crime analytics in investigation process, that is one of the utility. The algorithm decision making in justice delivery, that increases biasness. Further applicability of digital evidence in courts and e-courts and use of AI in administrative and governance mechanisms. There are a lot of benefits in respect of use of artificial intelligence and machine learning. But still the question related to privacy is in picture. Next slide. Now here the research methodology study follows the doctrinaire and analytical research design examining constitutional, ethical and legal principles governing use of AI and ML. The gap is that whatever we have done basically, the constitutional protection we have talked about in respect to case Puttaswamy case, particularly the proportionality test, data minimization, informed consent. What has not been done in near future we want to do is the question of empirical work in respect to understanding where that AI basically has deviated the question of right to privacy. Now the hypothesis is that the deployment of artificial intelligence and machine learning technologies in India legal and governance system, they pose significant ethical and constitutional challenges, including the right to privacy, and many current practices do not fully satisfy the principles that are laid down by K.S. Puttaswamy versus Union of India. Next slide. Concerns firstly, facial recognition systems and mass surveillance, Aadhaar-linked authentication concerns, predictive policing violating presumption of innocence, and automated decision making without human oversight. The fact is that the way state has actually taken up informations from the common people with respect to other obligations, it is very difficult that the private individual can come up and generally ensure the fact that that particular information is not being deviated and given to other organizations. The next slide. Now some highlights of the DPDP rules. This is a basic act which has been considered to have protected right to privacy, but here rules are rolled out in phases over 12 to 18 months. Certain provisions like registration of consent managers have their own specific timelines. Next is plain and specific consent notices.